Melania Trump is one of the less smart first ladies we've ever had. And she's married to one of the dumbest presidents we've ever had, certainly the most corrupt. And she's decided that she wants to fight back against journalist Michael Wolff. And by doing so, she's opened a tremendous can of worms about her marriage, about where she lives. And now personal data has come out in the lawsuit and in a motion that she's brought against Michael Wolff and his case against her related to a shakedown of Michael Wolff for billions of dollars because he properly reported the relationship between Trump, Epstein, and Melania.
Melania Trump has never been the most visible first lady, but what she is doing right now may end up being one of the biggest legal mistakes of her public life. In trying to silence a journalist, she has opened a legal battle that is exposing deeply uncomfortable details about her marriage, her residency, and her documented connections to Jeffrey Epstein and Ghislaine Maxwell. What began as an attempt to intimidate a reporter has turned into a procedural disaster that could unravel far more than she anticipated.
I mean, these are about 100 hours of conversations with Jeffrey Epstein. So it's a kind of a life in the tapes. I mean, he talks about he talks about a full range of his interests, of the details of the people who are around him.
This entire situation began with journalist Michael Wolff, who has written extensively about Donald Trump's relationship with Jeffrey Epstein. Wolff published material that Melania clearly did not appreciate. Instead of ignoring it or issuing a public denial, she responded with something far more aggressive, a $1 billion demand letter. Not a million, not 10 million, $1 billion. The letter threatened to sue Wolff unless he retracted statements about her alleged connections to Epstein and Maxwell.
So it is now Michael Wolff versus Melania Trump. I'm not the only one who has faced these kinds of lawsuits. This has just become their trick in the book. We don't want this discussion to go on. How do we stop it? We threaten people with lawsuits for billions of dollars.
And issued a formal apology. That number alone tells you what this was. It wasn't a realistic defamation claim. It was intimidation. It was a strategic attempt to financially crush a journalist into silence. But Wolff did not fold. Instead, he went on offense. He filed an anti-SLAPP lawsuit in New York State court last October. Anti-SLAPP laws are designed specifically to stop powerful individuals from using frivolous legal threats to silence critics. SLAPP stands for Strategic Lawsuit Against Public Participation. The law exists because wealthy figures have a long history of threatening massive lawsuits not to win on the merits, but to scare journalists into backing down.
Tend to sue me for $1 billion related to some of those statements. I'm not the first here. They have threatened and sued other people for saying similar things. These are called SLAPP suits. They may have really no chance at all of proving defamation, but they sue anyway in order to intimidate you and really to shut down any discussion of the relationship of Melania Trump, Donald Trump, and Jeffrey Epstein.
Wolff attached Melania's $1 billion demand letter directly to his filing. His argument was straightforward. This is an attempt to extort silence over reporting about documented Epstein connections. In other words, he framed her threat itself as abusive. And here's where it becomes legally fascinating.
The relationship of Melania Trump, Donald Trump, and Jeffrey Epstein. I can't live like that. And as a matter of fact, there's nothing I would like better than to get Donald Trump and Melania Trump under oath before a court reporter and ask them what are the details of their relationship with Jeffrey Epstein, what went on here.
If Melania genuinely believed she had been defamed, the logical move would have been to file a countersuit for defamation and prove Wolff's statements were false. But she didn't do that. Instead, she tried to move the entire case out of New York State court and into federal court in Florida. Her legal argument was based on something called diversity jurisdiction. In federal civil procedure, a case can be moved to federal court if the parties are citizens of different states and the amount in controversy exceeds $75,000. Melania claimed she is a Florida resident living at Mar-a-Lago. Therefore, she argued, the case belonged in Florida federal court, not New York State court. Now ask yourself why she would be so eager to get out of New York. The answer is simple. New York courts have not been friendly to the Trump family. Donald Trump and his children were hit with a massive civil fraud judgment there. The legal environment is not favorable terrain for them. Florida federal court, on the other hand, has produced rulings that were notably deferential to Trump in other high-profile cases. The venue matters. Judges matter. But in making that move, Melania created a serious problem for herself. Wolf's legal team responded with a filing that directly challenges her claim of Florida residency. And they didn't rely on speculation. They did investigative work. They contacted someone working at Trump Tower in New York who confirmed that Melania maintains a separate apartment there. Not the penthouse Donald uses. A different apartment entirely. A $1.5 million unit purchased in her own name in 2016, just before she became First Lady. That is not a casual property. That is not a vacation condo. That is an individually owned residence inside Trump Tower. And that's not the only evidence. Wolf's filing points to Melania's own public statements during the 2024 campaign cycle. She spoke about living in New York. Her son has attended school in New York. She has been photographed repeatedly in New York. A recently released documentary about her features footage placing her in New York consistently. Residency for jurisdictional purposes is determined by where you actually live, not where you vote once. Courts look at factors like property ownership, physical presence, family location, and declared domicile. Owning and residing in a Manhattan apartment strongly suggests New York residency. If a court determines she is in fact a New York resident, diversity jurisdiction collapses. The case stays in New York State Court, where anti-SLAPP protections are robust. There is another critical detail here. Wolf's team also documented how difficult it was to serve Melania with legal papers. Under the law, you must personally serve someone with a lawsuit. But serving someone protected by full-time Secret Service detail is not simple. Security barriers make physical access nearly impossible. Yet despite that, Melania filed the removal motion. That act alone demonstrates she knew about the lawsuit. You cannot argue improper service while simultaneously litigating the case. By filing that motion, she effectively acknowledged awareness of the lawsuit, undermining any procedural defense based on lack of service. But all of this legal maneuvering points to a deeper question. Why was she so desperate to silence Wolf in the first place? The answer becomes clearer when you look at what has come out since she sent that billion-dollar demand letter. The Epstein files have been released in part, and among the materials are documented emails between Melania Trump and Ghislaine Maxwell. The communications are cordial, friendly. They address each other warmly. They discuss meeting up. In one exchange, Melania compliments Maxwell on a New York Magazine article about Jeffrey Epstein. There are also well-known photographs of Donald and Melania at social events with Epstein. Video footage exists of them at parties. The associations are not speculative. They are documented. Now, none of this automatically proves criminal wrongdoing by Melania. Association alone does not equal participation, but it does destroy the foundation of any defamation claim. Defamation requires proving that statements were false. If Wolf reported that Melania had documented interactions with Epstein and Maxwell, and emails and photographs confirm those interactions, that reporting is factual. Truth is an absolute defense to defamation. And that is likely why Melania has not actually filed a defamation countersuit. She threatened one. She issued a billion-dollar demand letter. But when challenged, she pivoted to jurisdictional arguments instead of litigating the substance. That choice speaks volumes. What makes this even more revealing is the timing of Melania's demand letter. She sent it before the broader Epstein-related materials began surfacing publicly. At that point, she knew what existed. She knew emails and documentation tied her to Ghislaine Maxwell socially. She knew photographs connected her to events where Epstein was present. And she knew that once those records became public, any attempt to deny the relationship outright would collapse. So instead of waiting, she tried to stop the reporting in advance. That strategy only works if the journalist is afraid of the financial threat. Wolf wasn't. By filing an anti-SLAPP action, he forced the issue into court, where Melania now has to defend her intimidation tactic rather than quietly benefiting from it. Under New York's anti-SLAPP statute, If a court finds that a lawsuit or legal threat was intended to silence lawful speech on a matter of public concern, the defendant can recover attorneys' fees and damages. In other words, the law punishes exactly the type of legal bullying that billion-dollar demand letters represent. That's why venue matters so much here. New York strengthened its anti-SLAPP protections in recent years, specifically to protect journalists and writers covering matters of public interest. Florida's protections are narrower. If the case stays in New York, Melania faces a much steeper climb defending her threat. If it moves to Florida, she may gain procedural breathing room. But even in Florida, the underlying facts do not change. Emails still exist. Photographs still exist. Public statements still exist. And if she ever chooses to file an actual defamation claim, she would have to prove that Wolf made false statements of fact. That means discovery. That means depositions. That means document production. Discovery would open doors she likely does not want opened, because this case isn't just about Epstein connections. It has also inadvertently spotlighted details about the Trump marriage and living arrangements that have long been rumored but rarely documented in court filings. Wolf's team specifically highlighted that Melania owns and maintains a separate apartment inside Trump Tower, not a shared marital penthouse, a distinct residence purchased in her own name. That's unusual for a high-profile married couple whose brand has long revolved around unity and shared luxury. The filing doesn't speculate about the state of their relationship. It doesn't need to. It simply lays out facts about property ownership and residency. But those facts inevitably raise questions. Why maintain a separate apartment in New York if her primary domicile is Florida? Why publicly state affection for New York residency while claiming Florida residency for litigation purposes? Why anchor her son's schooling and daily life in New York while asserting she lives at Mar-a-Lago? Courts evaluate domicile by looking at intent and physical presence. Where do you actually spend your time? Where are your personal belongings? Where is your family based? Where do you maintain property? One voter registration does not override the totality of those factors. If a judge determines she is in fact domiciled in New York, the removal fails. The case stays put, and then Melania faces a difficult decision. Does she escalate and file the defamation countersuit she threatened? Doing so would require her to step fully into litigation on the merits. That would mean proving falsity. That would mean confronting the documentary record. That would mean potentially being deposed under oath about her communications with Maxwell. Or does she attempt to quietly resolve the anti-SLAPP claim and retreat? Either path carries risk. Escalating risks exposure. Retreating reinforces the perception that the threat was hollow. This is the danger of using oversized legal threats as intimidation tools. Once called, the bluff cannot easily be unmade. From a strategic standpoint, Wolf's move was aggressive but smart. Instead of waiting to be sued, he forced the issue into a forum where the threat itself becomes evidence. He turned her intimidation tactic into a legal vulnerability. And the deeper problem for Melania is that the context surrounding Epstein has shifted dramatically since her demand letter was sent. When Epstein was first arrested and later died, there was still ambiguity about how much documentation would ever become public. That ambiguity is shrinking. Court records, Maxwell trial exhibits, flight logs, social calendars, and correspondence have increasingly entered the public domain. Each additional document makes it harder to claim that reporting about associations is defamatory. The law does not protect public figures from embarrassment. It protects them from falsehoods. Those are two very different things. Melania is undeniably a public figure. As First Lady and as a longtime political spouse, she meets the highest standard under defamation law. To win a defamation case, she would not only have to prove falsity, but also actual malice, meaning she would have to show that Wolf knowingly published false information or acted with reckless disregard for the truth. That's an extraordinarily high bar. And if the reporting is grounded in emails, photographs, and public records, that bar becomes nearly insurmountable. Which brings this back to the original billion-dollar number. A legitimate defamation claim is calculated based on demonstrable harm. It requires showing actual damages. $1 billion is not a realistic projection of reputational loss in this context. It reads as a scare tactic, a financial sledgehammer intended to frighten. But scare tactics collapse when confronted with procedural reality. Now the court will decide residency, then potentially anti-SLAPP applicability, then possibly sanctions. Each step moves the dispute further into formal adjudication, where bluster carries little weight, and every filing becomes public record. That's the irony here. In attempting to suppress reporting, Melania has created new reporting. In trying to silence discussion of her Epstein connections, she has amplified them. In attempting to escape New York courts, she has forced the court to examine exactly where she lives and why. The more aggressively she fights this, the more factual scrutiny is invited. And scrutiny is not something the Trump orbit handles comfortably. What this case ultimately exposes is a pattern that has followed the Trump family for years. When faced with uncomfortable reporting, the response is rarely to refute facts directly. Instead, the response is to threaten overwhelming legal force, issue an astronomical demand, force the other side to decide whether they can afford to fight, count on fear to do the rest. But that strategy only works when the target backs down. In this instance, Michael Wolff did the opposite. By filing under anti-SLAPP protections, he flipped the power dynamic. Now Melania is the one who must justify her legal aggression. The court isn't asking whether she dislikes the reporting. It's asking whether her billion-dollar threat was an abuse of the legal system. And that distinction matters, because courts take seriously the misuse of litigation to chill speech, especially speech about matters of public concern. The Epstein scandal is unquestionably a matter of public concern. It involves criminal conduct, government investigations, public officials, and high-profile social relationships. Reporting on documented communications and social interactions between public figures connected to Epstein falls squarely within protected speech territory. If the judge finds that Melania's threat was primarily intended to silence that speech rather than pursue a legitimate claim, she could face consequences under anti-SLAPP provisions. That could mean attorney's fees. It could mean additional damages. At minimum, it means judicial scrutiny of her motives. And motives are where things get uncomfortable, because this wasn't just about correcting an alleged factual error. If that were the case, she could have issued a detailed rebuttal, provided contrary evidence, or filed a focused defamation complaint addressing specific false statements. Instead, she issued a sweeping billion-dollar ultimatum demanding retraction of coverage related to Epstein connections that are now backed by documentary evidence. That makes the intimidation angle far more visible. The residency issue adds another layer of credibility strain. Courts are not fond of litigants who appear to manipulate domicile claims for tactical advantage. If the judge concludes that Florida residency was asserted primarily to escape an unfavorable venue rather than reflect genuine domicile, that damages credibility before the case even reaches substance. Credibility matters in every motion that follows. If Melania loses the removal fight and the case stays in New York, she will be litigating in a jurisdiction with strong anti-SLAPP enforcement and recent precedent involving the Trump family. That alone raises the stakes. If she wins removal and moves the case to Florida, the anti-SLAPP terrain may shift slightly, but the evidentiary landscape does not. Emails do not disappear when cases cross state lines. Photographs do not change based on venue. Truth does not become defamation because of geography, which leaves her in a narrowing strategic corridor. Escalate and risk discovery. Retreat and reinforce the perception that the threat was hollow. Settle quietly and invite speculation. Continue fighting and keep the spotlight fixed exactly where she did not want it. There is also the broader political context. The Epstein files have become a symbol far beyond the original criminal case. They represent secrecy, elite protection, and unanswered questions. Any public figure connected, even socially, to Epstein or Maxwell is inevitably scrutinized more intensely than they would have been before. In that climate, aggressive legal suppression tactics rarely work. They feed the narrative that there is something deeper to hide. And that is the unintended consequence here. By attempting to bury reporting about her Epstein connections, Melania has re-centered those connections in public discourse. Every filing restates them. Every court motion references them. Every legal argument circles back to documented communications and associations. This is the paradox of high-profile litigation. The act of suing often republishes the very information the plaintiff hoped to erase. What started as a demand letter has become a jurisdictional fight exposing her living arrangements, property ownership, and documentary ties to individuals central to one of the most notorious criminal enterprises in modern history. That is not a contained story anymore. That is an expanding one, and the expansion is largely self-inflicted. None of this proves criminal wrongdoing by Melania, but it does demonstrate that the reporting she sought to suppress was grounded in real, verifiable evidence. That matters enormously in defamation law, because courts do not punish journalists for publishing uncomfortable truths. They punish falsehoods. At this stage, the burden would fall squarely on her to prove falsity and actual malice. Given the documentary record, that would be extraordinarily difficult. So the case now sits at a pivotal moment. The judge will rule on residency. The venue will be determined. The anti-SLAPP framework will either hold firm or shift slightly. And then Melania must decide whether to litigate substance or retreat. Either way, the strategy of intimidation has already backfired. Instead of silencing discussion of Epstein connections, she has ensured they are discussed in court filings, legal analysis, and headlines nationwide. Instead of controlling the narrative, she has handed control to the judicial process. And once a matter is in that process, it moves according to law, not preference. The more she fights, the more gets documented. The more gets documented, the harder it becomes to claim that reporting was invented. And the harder that becomes, the weaker any defamation argument appears. In trying to suppress scrutiny, she is guaranteed it. And that is a legal trap of her own making.